Hello, everyone. We are back again. Look at this fool acting like he on candid camera, trying to get himself ready. First of all, he need to fix his hairline. How you gonna take a picture with your hairline looking like who did it and why? All right, listen, we are back again. And if I can say, why is he trying to fix himself up? Like he about to take a selfie. Nigga, you about to go to jail. Does he think that prison is not imminent relative to his future? Anyway, let me say this. Let me pause it while we're waiting for the judge to commence with this trial. I want to say this. I really believe that Darrell Brooks represented himself for the sole purpose of already knowing that there was no way he can get out of this. This is why he got rid of Attorney Perry. Because here's the point. Even if Attorney Perry would have represented him, Darrell was still going to jail by default of the evidence. So in other words, he knew that there was NWO, that is the acronym of what? No way out. He emphatically knew that there was NWO. No way out. I ain't talking about the New World Order. I'm talking about no way out. And so he chose to represent himself for the sole purpose of thinking, well, you know what? Let me try to say crazy things, and let me piss the judge off so that way I can knock her off course and get her to react in such a way so that way that'll be my loophole in terms of appeal. Because if the judge becomes emotional as a result of my disruptions and me interrupting and pissing her off, as a matter of fact, that y'all remember hearing the judge say, you've been pushing my buttons all day. I'm just glad that even though those buttons that he was pushing didn't lead her to act in such a way that would warrant a mistrial. And that's exactly the anticipation by Mr. Brooks. He was anticipating a mistrial. He was trying on every level. It even started with him accusing, y'all remember him accusing one of the jurors in light of a Reddit post. He tried that gamut. That didn't work. And so let me hold on, stop! Hold on, y'all. I don't like being distracted. I thought I put this phone on Do Not Disturb. Not while I'm talking. Not while I'm talking. See, watch this. You see how that disruption just pissed me off? So can you imagine if I was the judge in the Darrell Brooks case? Guess what? If I can go off because of a sound, then I would go off if he interrupts. So that would mean that he would have won on a mistrial because of my uncontrollable emotion. But here's the point. The point is this. Judge Darrell was smarter than Darrell. She knew his plan. She knew he couldn't get out. She knew what he was doing. Hold on, let me put this phone on Do Not Disturb because I don't like being disrupted. Hold on. Hold on a second. Hold on. Hold on a second. All right. We got it on Do Not Disturb because I don't like being disrupted. But so let's just put it this way. Thank God I wasn't the judge presiding over that case going off on Darrell Brooks. because that would have fed into his gambit. But I thank God for Judge Darrell that saw his gambit and did not feed into his trap. All right, let's get into this trial. We're just waiting on the judge to come in. Look at this fool sitting there, his dumb behind, and they got a nerve to have a Bible. Listen, I believe in the Bible, but I also believe in common sense too. Common sense means you did wrong. You can't use no Bible to try to excuse you out of. Come on, just like, guess what? Every time I get a headache, guess what? I believe in God, but I also believe in Tylenol. Well, you didn't hear me. It's all right to believe in God, but you better believe in common sense too. You better take a Tylenol. It's all right to bring a Bible, but when you didn't kill 6 people, you better take heed to common sense. In other words, you're going to jail.
Versus Darrell Brooks, case number 21 CF 18.
All right, we're started. We're getting started. I didn't mean. All right, here's Judge Darrell. Court is in session.
1948 may have the appearances, please.
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning. Please state your name, sir.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client.
Liar.
I accept for value and return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not identify as that name nor consent to being called as that name.
All right, now let me just say this before the judge gives her expressions. Listen. You know what he just reminded me of? When I was a little boy, when I was coming up as a little kid, we used to read books. And there were 2 types of books that we read. There was fiction and there was non-fiction. And I remember that non-fiction book. And I don't know because I don't know if some of y'all, this will only apply to the era that I came up. In other words, if you were era after me, then you may not be able to align relative to what I'm saying. But here's the point, ladies and gentlemen. There was a fiction book called Clifford the Big Red Dog. And I know some of y'all want to know, why am I bringing up Clifford the Big Red Dog? Here's the point. Clifford the Big Red Dog was fictional. It wasn't real. So what does this have to do with Darrell Brooks? Didn't you hear what he just said? He said he's a third-party intervener, watch this, for his client. Don't that sound fictional, given that there's only one person there? There's only one person at that table. In other words, where's the client and where is the attorney? He sounds like a fictional book. Don't make no sense.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes. He's wearing a suit and tie. He's also wearing a mask.
Now, watch this. Notice the judge replied back and said, the individual. See, he talking about representing his client. So so if he got a client, then there should be 2 people there with his fictional self. But the judge saw through it and said the individual. Individual means one person. See, she's talking non-fiction and he's in the fictional section of the library. Yo. Oh, Lord.
All right, we are starting a little bit early today, given the extended break we had yesterday. Anything the parties wish to take up prior to the jury coming out from the state?
Just one thing, Your Honor. For the record, we have served all of the subpoenas for Mr. Brooks at his request. The subpoenas had indicated a report date and time of tomorrow, which would be October 14th at 8 a.m. Given where we are in the case, we do not believe that we will have rested the state's case by 8 o'clock tomorrow morning. We believe we're probably on track to rest sometime on Monday at this point. So with the court's permission, we would like to advise those witnesses that they do not have to report at 8 a.m. tomorrow, and that we will update them probably Friday afternoon as to a date and time to appear.
All right, let me say this. Now, this particular segment is when Mr. Brooks is questioning the dancing grannies. The dancing grannies. Let me say this. I kind of felt bad because you can tell that the dancing granny that was on that stand, of course, she's elderly, and Mr. Brooks was taking full advantage of that. But there is a segment in this trial that I want you to see that I thought that was good, because it came back to bite Brooks in his gluteus. Now, I ain't gonna say gluteus maximus because he looks like he's thin, so he might have a gluteus minimus. It came back to bite him in his gluteus minimus. And so I want you to see this, but let's listen to this. They're going over, I guess this is housekeeping before the jurors come in. So let's dive back into this.
Any objection to that procedure, sir?
No objection. Just wanted to state that those subpoenas were filled out, as you know, by your assistants, that they should have been filed with the date of the 14th at 8:30 a.m. So just wanted to state that for the record. And also, again, I do not consent or agree to being called that name.
Well, that's your name.
Your lack of consent is noted. I would note, though, you've not provided me with a different name.
Exactly.
Number one. Number two, every inmate communication form has the name Darrell Brooks Jr.
Exactly.
So I like to refer to the defendants by their name, frankly, out of respect for them.
Now, let me say something. Now, you notice, now watch this. He always kept asking about his ICFs. That is the acronym of what? Inmate communication form. When he signed that, he signed it by his name, which is Darrell Edward Brooks. That name was on that ICF. So if he wrote the name on the ICF, then why is he disputing what his name is? See, that don't even make sense. See? This man is, he's a fairy tale. It's fictional. It's almost like I'm in the library, but I'm in the fiction section. I'm in Clifford the Big Red Dog section. Y'all ain't saying that. I'm in the Bernstein Bears section. Y'all ain't saying nothing. You see what I'm saying? This is nonsense. If you don't go by that name, then why did you write that name down and then want to bring up your ICFs? The ICFs would have never been received if there had not been a name or a signature. So what is this fool talking about? He doesn't make sense. Just like Judge Darrell just said, you have not provided another name, because there is no other name other than Darrell Edward Sewer rat Brooks. All right, let's jump back in here.
Continually use defendant over and over again. Not that that would be improper, it's just a practice. So
now notice she said not that that won't be improper, but he also denied that by calling himself the alleged defendant. Notice she said she doesn't always want to call him by defendant. She calls him by his name, but he was also denying being the defendant. So this man is definitely fictional. He's fairy tale. It's just a figment of his own imagination. But my question is this: what good did that do him? That's what we have to understand. Given his current, I ain't gonna say prior, I'm gonna say current. What good did that do him? Given his current custodial status. Oh, you didn't hear me. All right, let's jump back in.
I'm going to still keep referring to you as Mr. Brooks.
Exactly.
Mr.
That's
Brooks.
his name.
Again, you've filed all sorts of inmate communication
By
forms
his name.
with that name.
Exactly.
You've never given me another name
Exactly.
for which to call you. So I just want you to know that's not a disrespectful
You know
thing.
what? It kind of reminds me of the Bible. There's no other name by which, come on here, man would be saved. Y'all ain't saying that. All right, let me jump in.
It's out of respect for these proceedings. But at times I'll still refer you as the defendant.
Which he is.
No disrespect taken whatsoever, Your Honor.
Man, shut up. That's your name.
For the record,
whatever, shut
I
up.
still would.
All right, listen. I want to fast forward to the dancing grannies, because this is that segment. I don't want to hear no more nonsense. I don't want to hear nothing fictional, because that's what he's getting ready to assert. He's asserting BS. And watch this. Does he really believe that the jury doesn't know his name, given that he identified by that name when he was initially captured, when this fool was captured? He said Darrell Brooks. He said Brooks. All right, let's fast forward. I want to get to the dancing granny. Hold on, y'all. All right, now here we go. This is one of the dancing grannies. Now Darrell is questioning her, and I want y'all to really listen in this. And watch how Darrell screws himself with this. Screwed himself. Why do I say he screwed himself? Because he wanted to have a fight with the judge. All right, I feel like I'm telling you about a movie. What good is me telling you about, what good is you see in the movie if I'm telling the movie? All right, let's listen in.
Did you ever file any claims related to the incident?
Uh-oh.
I believe not of the incident, no, because I was there when they were talking to the gals that weren't hurt. They were like interviewing us.
The four of you, correct? The four that one, the two,
Yeah,
the
all
two
of us.
cats.
Yeah, the ones that were left, yeah.
Do you know if they filed any claims related to the incident?
If what?
Do you know if they filed any claims related to the incident?
Objections?
Grounds?
Calls for speculation.
Grounds?
The way that he asked it is overruled.
Wait a minute. I still can't understand. You know what? Wait a minute. Whoa. You notice every time when the state objects, right? And they state it, he yells out grounds to try to drown out what they're saying, what they're stating in terms of the grounds. And I'm thinking he's probably doing that so that way when he goes to appeal, or try to get an appeal, he can try to say, well, they never stated the grounds. Well, he keep trying to drown them out. When the state says the grounds, he interrupts the state he keeps on saying grounds. But that didn't work either. And if the state is stating the grounds, then why does he keep on saying grounds? And then there's other instances where the state stated the grounds, but then he wanted the judge to give the grounds, which she's not required to do. And you're going to find that out later on in his questioning. Watch this.
So you may answer if you know.
Okay, no, because we were all together and came to every interview that they needed from us.
Do you recall seeing or reading any complaints related to the incident? Grounds?
Sustained as to the form of the question.
Exactly.
You don't have to answer that.
You don't have to answer that, dancing granny.
Should I rephrase the question?
No, it was
It was
sustained.
Sustained as to the form of the question.
Exactly. Wait a minute. How you gonna say should I read? What attorney asks the judge should I? Come on, if you're an attorney, you should know. But it was sustained, stupid.
At any time during any interviews with law enforcement, were you shown a complaint related to the incident?
Objection back.
Grounds?
Sustained as to the form of the question.
You ain't going nowhere with
Were
this.
you informed that it may be a possibility that you might be called to testify in this matter?
Wait a minute, hold on, let's go back. What did he say?
Were you informed that it may be a possibility that you might be called to testify in this matter?
Now, isn't that, wait a minute, now let me ask the audience a question. Isn't that a dumb question given that she's there? Do you think that she would be there testifying if she wasn't subpoenaed to be there? So what kind of question is that? You think I'm just going to go up, come to court in the absence of a subpoena to testify? What in the hell? Oh my, he's dumb. But I think he's asking that to try to confuse her because she's kind of older. But the court ain't stupid. That's where he's going wrong. The state ain't dumb.
A lot later, not at the time. I had no idea of testimony until
She was subpoenaed.
Would you say much later, as you say, would that refer to weeks, months?
months. I was in no shape at the time to testify or talk about anything.
Exactly, because she was devastated by the people who she knew that were killed. And by the way, let me ask the audience, how is this advancing his defense? Or if there is a defense, I'm still wondering. Okay.
Do you recall seeking to testify?
Okay, why would she seek to testify if she was subpoenaed to testify? That don't make sense. But again, I think he's doing that because she's elderly and he's trying to confuse her.
Wanting to testify?
No, I didn't ask to.
Exactly.
This just happened when we would be in our interviews with.
She was
And then-
subpoenaed, stupid.
So it would be fair to say that you were asked.
Yes,
Or
subpoenaed.
Yes.
Do you recall by whom?
The DA,
I
stupid.
imagine the DAs or
Who else would subpoena her? Donald Trump? Stupid.
When you say the DA's, do you mean the district attorney's office?
Oh my God.
Yes.
Did they ever identify to you as being the plaintiff in this matter?
Uh-oh.
Grounds.
Sustained.
Now this is where he gonna
Next
mess
question.
up.
Grounds for the substance, Your Honor.
Shut up.
Relevance grounds.
It ain't relevant. What's relevant is what you did and what witnesses saw you did. What you did.
Do you recall ever being told that there was a plaintiff in this matter?
Oh Lord.
No, it's just, I was interviewed a few times, the 5 of us, and that was pretty much the end of it.
He's trying to
until
confuse her.
Months ago, where
He's trying to confuse this older woman.
I think probably a little explanation is needed.
You trying to confuse Granny.
Are you aware what a plaintiff is?
Objection.
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Not relevant.
Next question, Mr. Brooks.
Grounds for the sustain, Your Honor.
Ask your next question, please.
Stupid fool! The state already told you. And if it was sustained, then obviously it's not relevant. What are you doing?
I am. I just want to know the grounds, just for the record, the grounds for the sustain.
It was already mentioned.
Ask your next question.
Your Honor,
He is
the grounds should
retarded.
be put on the record.
Oh my God.
Ask your next question. I'll address this all
Oh
at the
my
next
God.
break outside the presence of the jury. Ask your next question.
He is stupid.
Your Honor, with all respect, I think...
Ask your next question.
Under 90611, ask your next question, or I will determine
Close.
that cross-examination is now closed.
Close it.
I'm
Keep
gonna
going.
ask, I'm gonna keep going. I just think the
Watch
jury
this.
deserves to...
Watch
hear
this.
Mr. Brooks, I'm
testimony.
instructing you to stop
Exactly.
making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity to make legal arguments.
Not at all. Or testify.
Or to testify. You'll have an opportunity if you so
Not
choose
at
to
all.
do that later.
With all respect,
Next
that is not
question.
question fine. The jury just deserves to...
Shut up.
All right, under 90611, the cross-examination.
Close.
Determined. Sir, you didn't follow my very clear
Uh-huh.
instructions. Does the state have any follow-up? No, Your Honor. All right, thank you, ma'am. You may step down.
Objection to that, Your Honor.
Your objection's noted. Ma'am, you
I
may
was
step
not-
down, and
Uh-huh.
after she steps down, I will be excusing the jury for a few moments.
Ha ha.
Please rise for the...
Did y'all see how he just screwed himself? You see how he just screwed himself? Trying to challenge the judge. She kept on telling him, ask your next question. In other words, don't debate me. I'm the judge. I run this courtroom. You don't run nothing. As a matter of fact, you ain't no real attorney. You don't run nothing. You're shackled. You're a detainee. You have no authority. You screwed yourself. The judge kept on telling him ad nauseum, ask your next question. But he kept on wanting her to state the grounds. His dumb behind don't even know that the state already stated the grounds. And it was sustained. And so now he forfeited his right of questioning the dancing granny because he thought he knew more to the judge and tried to challenge her. And she closed off. She closed off his questioning, even though he had another question. You screwed yourself. Under 90611, that means authority. In other words, I control the mood and the order of this courtroom. You don't control nothing. I'm running the courtroom. Let's rewind back. I just like that because I like that. I like that expression on his face when she closed off his questioning. And I'm glad because all he was doing was trying to confuse Granny. He knew she was up in age, and he was trying to confuse her. Let's rewind this back. I like this.
Your Honor, with all respect, I think the jury
Mr. Brooks, under
deserves.
90611, ask your next question,
Ask
or
your question.
I will determine that the cross-examination is now closed.
I'm gonna
Keep going.
ask, I'm gonna keep going. I just think the jury
See where
deserves.
he's
to
screwing
get-
this
Mr.
up.
Brooks, I'm instructing you to stop making those statements. The
Right.
jury will disregard.
Notice so this is what he's trying to do. He's trying to make the jury think that, oh, this is biased because the judge is not stating the grounds. But the jury isn't stupid because they already heard the state object and state the grounds. And so the judge is not required to state the grounds, and the jury knows that. But he keeps on saying the jury needs to know. They already know. It was already stated. And this is why Judge Darrell said the jury will disregard. See? He's trying to play victim. That's his whole gambit. It ain't working. It ain't working.
This is the cross-examination. It's not your opportunity to make legal arguments or to testify. You'll have an opportunity if you so choose to do that later.
With all respect,
Next
that is not
question.
fine. The jury just deserves
See,
to know.
you're
All right,
screwing
under
yourself
90611,
over.
cross-examination
I still
will
have
be
a question,
determined.
Your Honor.
Sir, you didn't follow my very clear
He sure enough
instructions.
didn't.
Does the state have any follow-up? No, Your Honor. All right, thank you, ma'am. You
Objection
may
to that, Your Honor.
Your objection's noted. Ma'am, you
I
may
was
step
not-
down, and
You screwed
after she
yourself.
steps down, I will be excusing the jury for a few moments.
You screwed yourself.
Please rise for the witness and for the jury.
Watch this. Notice he had more questions, but he screwed himself because he wanted to challenge the judge and he got screwed. You dumb. I can't say that. I'm still a Christian. But y'all know what I wanted to say. Or should I say what I desired to say? Y'all
Leave the courtroom.
Exactly. You stupid. You're dumb. Trying to challenge a judge that has way more experience than you. You know nothing. Why would you challenge her? And you got screwed. But you did that to your own self. Shut up,
Mr.
ain't no
Brooks,
damn all
please
due respect.
Wait.
Wait till the jury is excused. Stupid.
You may have a seat, everyone.
And by the way, let me just say this. I felt bad for Granny because she was up in age and he was taking full advantage and trying to, oh yeah. But I'm glad that he screwed himself because that was protection. To Granny, Granny was protected because of Darrell Brooks being inept. He's inept. He's an inept attorney. And so his ignorance, his stupidity, his ineptness, come on here, inadvertently became the protection to Granny. Because as a result of him impugning, come on here, Judge Darrell, that led to the close of his questioning of Granny. So I guess you can say it's bittersweet. It was bitter that he was questioning Granny and trying to confuse her. But it was sweet because his ineptness closed off his questioning of Granny. Well, you didn't hear me. Well, you didn't hear me. Woo! All right, let's get back into this trial.
On to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion. And
Oh, wait a minute. No. Hold on. Where we at? Hold on, y'all. I hit the wrong button. Hold on. All right, so here we are. The judge is excusing the jurors out of the courtroom so that way the judge can basically explain the law to him, to explain court proceedings. And so watch how the judge brilliantly explains the law, even though she don't have to. I ain't never known no judge to have to explain the law to an attorney. But in theory, Mr. Brooks, I think it's fair to say that he's not an attorney. So that makes sense. Let's jump back in here. She's waiting on
to specifically address
exactly
the repeated request by Mr. Brooks for the court to state the grounds. Sir, I am not legally required to do that.
Exactly.
Those are legal determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times. In fact, you're asking me to provide that explanation and really...
In other words, it's not obligatory. It is not obligatory for her to state the grounds, particularly or especially when the state already stated the grounds and it was sustained by the judge. So again, he screwed himself by wanting or requesting the judge to state the grounds when the grounds was already stated, and he failed to move forward in his questioning, which led to 906. Come on here, the authority of the judge that gives her the authority of the mood of the interrogation of the case. She shut down his questioning. Why? Because she had authority. She's the umpire, which means she's presiding. She's over this. She's running this. Not no so-called wannabe attorney that's sitting in Dodge today. You didn't hear me.
Highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection. It's a party makes it, states the grounds. Sometimes I ask the opposing...
Notice what she said, states the grounds. In other words, the state stated the grounds. So if the state stated the grounds, then why are you requesting the judge to state the grounds? You fool! You fool! You are a fool!
Party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay
They're always baseless.
Objections are baseless.
That's why it's
your
overruled.
objection to hearsay is it's not hearsay. So that's why to me they're self-evident. I say sustained and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury, which I don't feel is necessary.
It's not.
For the reasons that I've already stated. That.
Well, watch this. He wouldn't know that. He's only an attorney. You ain't telling him nothing, Your Honor. He's an attorney. He knows everything, doesn't he? He knows how to be an inmate at Dodge.
You're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. Again, not a sign of disrespect. It's The record is self-evident. Many, many times, if I feel that
listen,
more
did you hear the judge laugh? Because she know this is comical. Listen, let's listen to Judge Darrell laugh. I heard a little smirk in there.
jury, which I don't feel is necessary for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. Again, not a sign of disrespect. It's the record is self-evident.
Y'all hear that? Y'all hear that smirk? She said, self-evident. But Judge Darrell, he's only a defense attorney. Of course, he knows what you're talking about. And of course, he knows how to be an inmate as well. Or should I say a number? They ain't calling him by Brooks, they calling him by a number.
Many, many times, if I feel that more argument is needed, I'll excuse the jury. But I haven't felt the need to do that up until this point. And I will caution you once again, sir, 90611 is the statute, mode and order of interrogation and presentation.
Exactly.
Controlled by the judge.
Notice she said controlled by the judge. Not by a so-called attorney. The attorney does not run the courtroom. Y'all remember when Sue Opera said, he is not in control, you are in control. Exactly, the judge. But he thought he was at Burger King. In other words, he wanted it his way. You ain't at court. You ain't at no Burger King. And the food that you eating at Dodge, I bet you wish you was at Burger King. Oh, come on, yeah.
Shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective for the ascertainment of the truth. B, avoid needless consumption of time. C, protect witnesses from harassment or undue embarrassment.
Now listen, let me ask, now I have to ask this question again. Yet again. Y'all remember when Brooks kept on saying, you holding me in contempt yet again? Well, I got to say this, what? Yet again. Have you ever heard of a judge having to go over protocol with an attorney? All this is just a testament. This is evidence. This is proof. It's flagrant. It's blatant. It's obvious. It's evident. I can't think of no more synonyms. That this man is not an attorney, nowhere near. He's not adjacent to being an attorney. Absolutely not. And so she's going over this as a result of his ignorance, as a result of his neophyte position on this. Watch this. I like money, and money is green, but I don't like to be green, because when you green, that means you don't know. Watch this. I'd rather take the money rather than being green. Oh, you didn't hear me. You didn't hear me. And so she's trying to talk common sense to him. But as I told you in a previous video, that Mr. Brooks his ego had a little too much to drink. Sometimes when you drink alcohol, sometimes you can think that you are more than what you really are. Or in this case, he thinks he's brighter than what he really is. And so I think, once again, his ego had a little too much sipping Let's get back in here.
And it goes on, but for purposes of what I'm going through, that's the most relevant portion of 906.11. So when I give you the warning that under 906.11, I will cut off your cross-examination, it's because you're violating 906.11.
Of course it's violation.
So-
That a judicial determination.
Shut up.
Violated 906.11 when.
I'm advising you, sir.
Shut your mouth.
It's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 906.11 throughout the questioning of witnesses and the presentation of...
First of all, 906.11 means the judge has complete authority. This is what he doesn't understand. And this is why when you go back, watch this. When you go back to preliminary, the judge expressed to Mr. Brooks ad nauseum the hardships, the opposition, the inability to be able to subpoena witnesses. Notice I said the inability to subpoena witnesses. Why do I say that? It's because if he's in custody, then how does he have the wherewithal to subpoena witnesses? Guess what? There was an auxiliary, watch this, by the state. The state was the auxiliary. In other words, he needed help. Auxiliary means help. He couldn't do that by himself. And I really believe the state ultimately knew they had it in the bag anytime they got to help him or be the auxiliary of his desire to call witnesses. And even when he called witnesses, I still don't see his defense. What was his defense? Let me play victim. Let me pretend that I didn't kill 6 people and injure many. Is that my defense? Is that my defense? Come on. And so I think the state only, and watch this, here's the point, y'all. The state did not have to do that. They didn't have to be the auxiliary. I ain't never know the prosecution to help a defendant. Never known that. And I've studied law for years. I never seen the state help a defendant. Well, what does that say? That lets you know that the state already knew they had this in the bag. That they was willing to help him even though they knew that help that we're giving him is really to no avail. And apparently it wasn't to no avail, given his current custodial status. All right, let's get back into this.
Evidence.
Your Honor,
So with that, we're going to continue. I'm going to have the state be ready with their next witness.
Your Honor, I'm not interrupting you. I'm letting you make a clear record.
Shut
Mr.
your
Brooks, you
mouth.
have actually interrupted me.
I just let you go through the whole citing of 906.11 without saying.
Okay, she didn't
I'm
ask
not
you.
asking for the parties to make an argument under 906.11.
So
I'm
why would you?
advising you. Stop interrupting me, please.
Yeah,
I'm
shut up.
advising you, sir, so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited.
Notice she said have more knowledge and awareness. Can you imagine a judge talking to a real attorney saying that I'm citing this so that way you can have more knowledge and awareness? That would be an insult to a real attorney, wouldn't it? Wouldn't it? So this lets you know, not only was he a neophyte, Excuse my language, y'all. Can I get away with this? But he was a dumbass. I did say that ass is in the Bible. So I guess I can get away with it. Listen, y'all comment on this video. Let me tell y'all something. Mr. Brooks is so dumb. It's easy to make a video on him and make him look stupid. Touch a neighbor and say, if something is stupid, then it's not hard for you to make him be stupid. It ain't hard. Watch this. He's already dumb. And so if he's already dumb, then he's the auxiliary of me bringing up dumb stuff about him. Just like he was no attorney. So that meant he was the auxiliary for the state to incarcerate him or incriminate him even more. Sometimes being dumb could be valuable. It may not be dumb. It may not be valuable for the person that's dumb. But it might be valuable to the prosecutor. You dumb. Oh. All right, we're getting ready to go now. I want you, the audience, to comment on this segment. And guess what? There's going to be more. There's going to be more that I have to say regarding this other fool. But I want you to comment on this. Let me say this. I did not like when he was questioning the dancing granny. And let me say this. If you notice, and y'all go back and watch this trial, there was friends that she knew that died, that were killed. I believe that she even testified and said that they were killed instantly. And then he gonna impugn her by saying, well, if you didn't see it, then are you a doctor? How do you know that they died instantly? And then she kept telling him that paramedics were there working on the bodies, trying to revive. But to no avail. It's almost like Darrell Brooks thinking that he gonna get out of this. Watch this. It all comes back to no avail. Yeah. And why are you at Dodge? Because your defense was to no avail. Just like watch this. Do y'all remember? Watch this. Do y'all remember when Judge Darrell kept saying to Darrell, it was basically ill-advisory. And why was there ill-advisory? Because she's the judge. She knows. You got to remember, the judge went to school for this. It ain't easy being no attorney. And Darrell Brooks ain't no damn attorney. And so if it's hard for somebody trying to be an attorney, then let me ask you this, then how much harder it is for somebody that's not an attorney trying to represent themselves? Watch this. In the light of this high profile case. Watch this. With evidence showing him. How is he going to get out of this? See, common sense would say, nah, nigga, you ain't coming. You ain't getting out of this. And this is what makes me believe this. I believe I said this in the preliminaries of my comments, but I'll reiterate by saying this. I wholeheartedly believe that Darrell Brooks had a plan. In other words, he already knew. I'm reiterating. But I believe that this reiteration bears that repeating. Listen. I wholeheartedly believe that the reason that he wanted to represent himself, because he ultimately knew or ascertained that he was not escaping or coming out of this. And so he figured, well, let me represent myself. And let me be obnoxious during the trial. I believe the state had indicated to the judge that there was a phone call involving Mr. Brooks, watch this, and his enabler, or should I say his co-conspirator, his mother. Child, she a mess. She is a hot mess. But furthermore, there was a phone call involving Brooks and his mother. And the state had said that they heard Mr. Brooks saying what? That he was going to delay all of this. That was his gambit. Gambit means strategy. That was his strategy. Let me represent myself. Let me delay this by my interruptions. Let me pretend that I have COVID. Even though the judge asked me that I want to take a rapid test, let me deny that, but still say I'm worried about COVID. See? How you worried about having COVID, but then you're offered a rapid test, and then you say you don't want to do a rapid test? See, that don't make sense right there. So that means your claims is questionable. Ooh. You didn't hear me. That means I don't see, watch this, I don't see any credit relative to your credibility. How you gonna say you afraid? Y'all remember when he said he was afraid and he knew people that died of COVID? All right. Well, now you're given an opportunity of a rapid test. If you so concerned about you or possessing COVID, wouldn't it make sense to take a rapid test to find out if you are a recipient of COVID? But guess what he did? He denied. He didn't want no rapid test. So what is the judge thinking? What is the judge thinking? The judge is thinking just like anybody with common sense would think. In other words, if you so worried about this, then why are you declining or denying? Why are you not wanting to be participatory relative to a rapid? You know what rapid means? Rapid means now. Rapid is the antithesis of next week, next month. What is antithesis? Antithesis means the opposite. And so my point is, if he was so pensive and reflective and so gun-ho relative to his concern of potentially having COVID, then why didn't he want to take a rapid test to let him know right away if in fact he was a recipient or if he wasn't? Exactly. This man is a liar. And then now we found out why he didn't want to take a rapid test, because he knew he didn't have it. And as it was later proved that there was no positive COVID regarding Mr. Brooks. All right, I'm going to go. I got to go. Listen, I want the audience. To give me your opinion on this. I know we've been everywhere tonight, but y'all know me. Y'all listen to Lawrence Lyles. Y'all my friends. I love y'all. Y'all my audience. I love y'all. I love y'all to death. Thank you for listening. And I anticipate that this channel will grow to the crescendo reflective of my desire. Does that make sense? All right. God bless you now. I love y'all. I love y'all, the audience. Y'all please respond. Let me give y'all a big kiss. Mwah. All right. Y'all respond. And y'all comment. Let me say that your comment is important. Your comment is important. Bless you now. Bless you. We love to hear from the audience. Bless you.